Hello friends, today's class is contract of bailment, and this is another concept under special contracts. So bailment means delivery of goods from one person to another person for some specific purpose. Once the purpose is completed, it should be returned or it should be disposed of according to the directions given by the owner. So generally this type of contract we will enter day to day life, but we don't know that is the contract of bailment. When relating to the repair of your bike or mobile, or when you have delivered your cloth, that is unstitched cloth, to the tailor, all these things are come under the purview of bailment. So let's have a look on the definition of bailment. A bailment is the delivery of goods by one person to another for some purpose, and upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. And here one person delivering the goods to another person for some specific purpose. As soon as the purpose is completed, it should be returned to the owner or it should be disposed of according to the directions given by the owner. Means A delivered his bike to B for repair. As soon as the repair is completed, B should return the bike, A should pay the charges. And coming to this one, otherwise disposed of. A delivered one parcel to B. B was running a courier service. A delivered one parcel to B and asked the B to deliver the same to C. Now A is the bailer, B is the bailee. So he was delivering the parcel to B and B should dispose of this parcel according to the directions given by the A. That means B should deliver this parcel to C. The person delivering the goods is called the bailer. The person to whom they are delivered is called the bailee. So the person who delivers the goods is known as bailer. To whom the goods were delivered is known as bailee. And under section 148, in explanation, you can observe finder of lost goods. We will see the finder of lost goods in the next video elaborately. And coming to the classification of bailment, bailment has been classified into two types: gratuitous bailment and non-gratuitous bailment. Gratuitous bailment means bailment without consideration. Bailment without consideration. That means without expecting anything. When you are delivering your bike or car to your friend, that's called gratuitous bailment, and you are not expecting anything from your friend. So in this case, when you are delivering the car to your friend, you are the bailer and your friend is bailee. And coming to the non-gratuitous bailment. In the case of non-gratuitous bailment, this is nothing but bailment for reward. So when you are delivering your bike, car for repair, or your unstitched cloth to the tailor for the purpose of stitching, this was come under the purview of non-gratuitous bailment. And when you observe the definition, the following essential features of bailment. Number one, delivery of possession. In order to constitute bailment, there must be delivery of possession from bailer to bailee. And the second one is contract. There must be some contract between bailer and bailee. That means as soon as the purpose is completed, bailey should return the goods to the bailor, or it should be disposed of according to the directions given by the bailor. And the third one, delivery of goods for a stated purpose. And when you observe the definition, the main aspect of the definition is the goods were delivered to the bailey for a particular purpose, and as soon as the purpose is completed, it should be returned. Duties of bailey. Number 1, duty to take reasonable care of goods bailed. Bailey should take reasonable care of the goods which he was bailed from the bailor, just like his own goods. He should take proper care of the goods which he was bailed. Number 2, not to make any unauthorized use of goods. Unauthorized use means when the goods were delivered for a particular purpose, if the bailey used the same for some other purpose, then it will be called as unauthorized use. Let's take an example. A hired his car to B, and B promised that this car is only for my purpose only. So I will use this car for my personal purpose. But B delivered the car to C. So A is the bailor. Since he was delivered the car to the B for rent, B was not supposed to give this car to C, since he was promised that I will use this car. So here B's use of car is unauthorized use. And the next one, not to set up adverse title. Title means ownership. Bailey was not supposed to make any title, that is ownership. That means he cannot create any fake documents relating to that goods. And duty to return the goods. As soon as the purpose is completed, the goods shall be returned to the bailor. When he fails to return the goods, even after the purpose is completed, even after the period is completed, stated period is completed, he should bear the loss. And duty to return any accretion to the goods. Accretion means addition. Generally, this will happen in the case of animals. That means A, he was delivered his cattle or his pet animal to B for safe custody. And at the time of delivering the cattle or pet, that particular animal was pregnant. And while returning the A, that cattle was having calves or pet have puppies. B, that is bailey, should return cattle along with calves or the pet animal dogs along with puppies. And this will be happen only in the case of animals. And duties of bailor. So what are the duties of bailor? Number 1, to disclose known faults. When the bailor was delivering the goods to the bailey, if that good has having any faults, known faults, for these faults, bailor is liable. And we can classify this point under two things: gratuitous bailment, non-gratuitous bailment. In the case of gratuitous bailment, that means free of cost, without expecting anything. In the case of gratuitous bailment, bailor is responsible for only known faults. That means He know that there was something fault in that good. He should disclose the same to the bailee. When he failed to disclose the same to the bailee, if bailee suffered any loss, bailor is responsible. In the case of non-gratuitous bailment, non-gratuitous bailment means bailment for reward. In this case, if bailor is aware about the defects or if the bailor is not aware about the defects, he is liable. For example, if A delivers his car to B, who is a friend of A, for free of cost, and that car is having some technical problem and which leads to the accident and which causes some damages to B. Now, if A know about the defects on that good, that is car, he is liable. And when you observe the same example under non-gratuitous bailment, that means if A delivered his car to B on rental basis, if A is aware about the defects or not, A is liable if that car causes any loss to the bailee. And the next one, to bear expenses. So expenses relating to the goods. In the case of gratuitous bailment, that means free of cost. In the case of gratuitous bailment, bailor has to pay ordinary and extraordinary expenses. So in the case of gratuitous bailment, both ordinary and extraordinary expenses. Whereas in the case of non-gratuitous bailment, bailor is responsible only for extraordinary expenses. And the next one, to indemnify bailee. Indemnify bailee. So generally, this one is arise if the title of the bailor is defective. That means A delivered his car to B on rental basis. In fact, that car was not owned by A. This car was stolen by A from C. The same has been delivered to B on rental basis. While using the car by B, and C approaches B and he climbed the car since he is the owner and he filed a case against B. Now B can recover whatever amount he was suffered due to these legal consequences from A, who is a bailor. And the next one, premature termination of gratuitous bailment. Premature termination of gratuitous bailment. So gratuitous bailment means bailment without any reward, free of cost. In the case of gratuitous bailment, bailor can terminate the bailment at any time. He can terminate at any time. But if he terminates the bailment even before the stipulated time, if bailee suffered any loss rather than benefit, bailor has to pay the damages to bailee. And when bailor's title is defective, so bailor's title is defective, just like this case of indemnify bailee. So here A was delivered his C's car to B. Now in this case, now bailee has to deliver this car to, generally he will deliver this car to A only since he delivered the car, and he don't know about whether this car is owned by C. When he delivered this car to A, he is not liable since He doesn't having any idea that C is the real owner of the car. And duty to receive back the goods. There is a duty on the part of bailor. He should receive back the goods from the bailee as soon as the purpose is completed, and to bear the risk of loss. While using the goods by the bailee, if any loss was happened to the goods, that means A delivered his car to B on rental basis. There is no negligence on the part of B, that is bailee, if he met with an accident, and the loss of the car, it has to be borne by bailor. Since he is the owner, he was not delivering the ownership rights to B, he was delivering only the possession. He was not transferred his ownership rights to B. He was delivering the possession to the B, that means bailee. So he has to bear the loss. So in another video we will see the rights of bailee and rights of bailor. See you friends.